This is the second part of the Chapter 12 lecture. We left off where you have hopefully viewed the videos for both private and public nuisance. We're picking up after the public nuisance video in the order in the chapter folder. So as was discussed in the videos, public nuisance is dealt with by some governmental official, whether that be a city, a state, a county, a particular agency within any of those. Those are the types of entities that are trying to enforce particular statutes or ordinances that are related to nuisance. So in a public nuisance case, there's going to more likely than not be a particular statute or ordinance that the nuisance dweller is subject to. Okay. Our next topic is nuisance per se, and if you remember when we talked about negligence per se, this simply means that a public nuisance per se is an activity that violates some statute that was created to deal with these types of situations. And those statutes can also declare that certain private nuisances are per se nuisances, meaning that you are violating that statute by doing whatever it is that has been deemed a nuisance in that community, county, city, whatever the governmental entity is. So, as you remember, when we talked about negligence per se, it simply means that nuisance per se, you are violating some statute dealing with nuisance, and you are automatically deemed a public nuisance by the violation of that statute. Okay, courts generally don't recognize coming to the nuisance as a defense in public nuisance cases. Remember, we talked about in a private nuisance that if the defendant can establish that the plaintiff actually came to the nuisance, knew it was there when they came to the area, became the neighbor, whatever the case may be, then that can act as a defense for the party that is creating the nuisance. In a public nuisance, it's a harm to public at large, and so you can't say that the entire public at large has come to the nuisance. Okay, so what are some of the remedies for nuisances besides in the video as we watched, that the second video that was actually from Washington State, I believe, getting that person out of the nuisance, hopefully putting an end to the nuisance. But there are some remedies that we can take, okay? So when you sue for nuisance, whether it's public or private, there are several forms of relief. You can seek money damages, but really that's usually not your goal when you're dealing with a nuisance. Your goal is usually abatement. That's the gold ring, so to speak, if you are dealing with a nuisance in your neighborhood, or if we're dealing with a client who has a nuisance issue. So abatement is when the defendant is ordered to cease or abate the nuisance activity, and that abatement is many times permanent. Okay, so it's a court order directing the defendant to cease the nuisance activity, It can be enforced through injunctive relief, which could be temporary, meaning a temporary restraining order, or it could be a permanent injunction. You know, it may start out temporary and giving the defendant an opportunity to clean up whatever that nuisance is, deal with whatever that nuisance is, and then if they don't, into a permanent injunction. So the video from Washington is where, you know, you're basically have a permanent injunction and have basically, you know, the government has exercised eminent domain over that property and has seized it for being a nuisance to the community. So injunctions are court orders to the defendant to cease and desist. And as I said, you could have temporary or permanent injunctions with regard to the nuisance individual. And as I said previously, money damages are, sometimes you can get money damages, but if there has actually been some severe economic burden, but to you in your property, but normally it is really just to get the tortfeasor to stop doing whatever it is that they are doing, or creating whatever nuisance it is that they are creating. So our next topic is about some other special situations in tort law. The first is what are called survival statutes. Under the common law, if a plaintiff died as the result of the tort action, or for some other reason, his or her tort case died with them. Okay, meaning you could no longer pursue it. So states passed what are called survival statutes, and those allow the families of the person that died because of these tortious actions to bring the action on behalf of the decedent's estate, and any recovery that is achieved goes to the decedent's estate. You also, and I think we may have discussed this in class before, but most states also have what's called a wrongful death statute. It is the opportunity, the avenue for surviving family members of a deceased tort victim to bring an action against the tortfeasor. It is on behalf of those family members, what they have lost because of this action that has killed their family member. Okay, so it's not on behalf of the estate so much as it is on behalf of whatever remaining family members have lost that companionship of that individual. Okay, damages in wrongful death cases usually include lost lifetime earnings potential, meaning, you know, if this person who died as a result of this tort action was the primary breadwinner in a family, or even, you know, a contributor, then you would go through a damage assessment and ask for those future lost earnings, what the family has lost out on as far as economics. But then you also can sue for what's called loss of consortium, which is loss of the companionship of that person. And the defendant in, or the tortfeasor in any of these wrongful death actions can use any defense to torts that we've talked about as a defense, whether that be self-defense, assumption of the risk, contributory negligence, all of those are available to advance as a defense for the tortfeasor. There's also a tort known as wrongful birth. Not every state recognizes it. Wrongful birth actions are for the birth of a unwanted child. Usually these cases deal with parents who thought or were assured that they had gone through a sterilization process, you know, a tube tying or a vasectomy, and then, whoops, surprise, a baby is born of one of those sterilization procedures. Okay, usually, you know, it's going to be some type of OBGYN, genetics counselor, someone who has, you know, supposedly assisted this individual in preventing future pregnancies. We also, it's also a form of medical malpractice. You can seek emotional distress, the cost of any prenatal care, and any expenses associated should the child have an impairment. You usually cannot get damages for, you know, the future expenses of this child if they are a normal, healthy, normal is not a good word, but a healthy child. So the final tort we're going to look at is called wrongful life. Probably not the best name for it. It's not recognized by every state. In fact, it's only a very small handful of states. Georgia does not recognize it, and kind of falls into two different categories. One is similar to wrongful birth in that it is it's a pregnancy or a child that is the result of a failed sterilization, you know, meaning that one of the parents has either had the vasectomy or had their tubes tied or some type of sterilization procedure, and yet a child has been born of that that person, even though they've had some type of sterilization procedure. The other is for a child who is born with birth defects that were or disabilities that were not diagnosed during the pregnancy, but they should have been. So it's not really fair to call it birth defect because it might not be something that actually happened at birth. It could have been something that should have been discovered in vitro and was not. So that's the second aspect of wrongful life, and usually, you know, you're going to recover, or you're asking for damages to cover the pregnancy in both of these types of wrongful life cases. So you're asking for expenses of pregnancy, delivery, and sometimes, depending on the particular jurisdiction, you might be asking for the cost of raising this child who has these impairments. So that's the end of chapter 12.